Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. We have some breaking news, some information to share with you. In a prior episode of our content here on YouTube and also in the Idaho versus Kohberger podcast, we noted that one of the parties on May 2nd filed a notice of penalty phase lay witnesses and request for victim impact statement. It appears on the very last page of the case summary page, page 91. And what this says is that May 2nd, 2025, notice, PDF icon next to it as you see here. That tells us that this is a public document. Although it still has not appeared on the court docket as of today, May 6th, 2025, and the court docket was updated today. The way that the Clerk of Court described this document made it difficult to understand if this was a state or if this was a defense notice of penalty phase lay witnesses and request for victim impact statement. We were a little confused why the request for victim impact statement would be asked for nearly 3.5 months before trial. Trial does not start, case in chief, until August 11th, 2025, with the what's called here the guilt phase of the trial. This is how Judge Hippler has identified it in the October 9th, 2024 pretrial and trial order. But you'll see here that what Judge Hippler indicated is that the guilt phase of the trial will start August 11th, 2025 at 8:30 a.m. and this trial will continue until November 7th, 2025. Inclusive of the penalty phase, if any. And that is an indication that there may not be a penalty phase. If that jury returns a verdict of not guilty, this case ends. Mr. Kohberger can never be tried again on these charges that he was indicted on, that he will face trial on, the 5 felonies, because double jeopardy will attach. That is a constitutional protection. And if there is no penalty phase of this trial, there will be no victim impact statements, because victim impact statements, let's say it's a battery that was perpetrated on someone, the victim would then typically get up and explain how this crime impacted them physically, mentally. Maybe it impacted their ability to work, to earn a living. If it's a case of unaliving, then it's typically the family members, the parents, the spouses, the children of the victim that will get up and will give a victim impact statement to explain what the crime, what the loss of their precious loved one has meant in their lives. Additionally, although the penalty phase lay witness lists were due to be filed per this October 9th, 2025 order under seal on or before May 5th, 2025, there is nothing in this entire order, including under the section that directs the deadline for the filing of the penalty phase lay witness lists, describing a victim impact statement at all. Fast forward a few days. The docket has been updated today, May 6th, and there's 2 newly filed items that appear as of today. They are both dated May 5th, 2025. The first, as you see here, motion to redact or seal newly filed records, motion to seal defendant's phase 2, mitigation witness list. PDF icon next to it tells us this is a public record. It will appear on the docket, as will that notice of penalty phase lay witnesses and request for victim impact statements of 3 days earlier. However, the next item, as you see here, the lock and key icon tells us that the second document filed by the defense of May 5th, 2025 is not a public record. It is under seal. It is described subject document, motion to redact or seal newly filed record. This is the penalty phase lay witness list of the defense. So if the defense filed their witness list right at the deadline of the 5th of May, and there's nothing else on here describing the state's penalty phase witness list, it stands to reason that that document of May 2nd, 2025 was the notice of penalty phase lay witnesses and request for victim impact statement. That was the state of Idaho's filing. These documents do not yet appear on the docket. However, the defense has, since the beginning of this case, filed documents. They will file a motion to seal or to redact along with whatever it is that is being asked to be placed under seal so that the judge can see it at the same time. They're done contemporaneously. There would be no reason for the defense to file a notice of their penalty phase witness list and ask for this victim impact statement or statements, and then 3 days later file the same thing again. We will know for sure once these documents hit the docket. One other thing that I wanted to bring to your attention today. We see here no order out of the May 5th hearing. We've done some content before regarding the speculation over this hearing that was noticed April 30th, 2025, or just a couple of days before what appears to be the state's witness list and request for victim impact statement. That hearing did happen May 5th, 2025. We know that because the court minutes here, along with the notice of hearing that noticed this hearing with no subject and no topic, absolute first for this case, the minutes tell us that it memorialized that hearing. There's no order from that hearing as of yet. If this was on a motion, some are speculating that this hearing was on the state's motion for an examination of Mr. Kohberger, which the defense had apparently filed an objection to, all under seal, so we're not able to see anything other than the descriptions on the case summary page. There needs to be a court order. The court has to make a ruling, and that ruling needs to be in writing. There is nothing here on the case summary page as of yet that shows any order from Judge Hippler under seal or that is a public document. We're going to continue to monitor the case summary page and the docket itself as further developments arise. If you have any comments, any feedback, please leave it here. And if you like our content, we'd greatly appreciate it if you would hit the like button and also consider subscribing to the channel if you haven't already so that you can receive notifications of our new content. This is Kathy. Thank you as always for joining us here today.